Okay. And then she'll also help me keep people on mute and monitor the chat. You can enter questions in there as we go along, and then we can address them at the end as well. So we'll do the first hour, which is inspecting violations and giving notices. We'll take a quick break, do a poll question, and then go into meeting with violators and resolving issues. So yeah, the first part is, like I said, inspecting. So what is floodplain management? It's about reducing vulnerability to flood risk in our built environment. So if we know an area is going to flood periodically, then we need to make reasonable decisions to protect families, homes, and businesses, or as we say, protect life and property. So this is a community-based effort to prevent or reduce risk. It's also sometimes used as neighbor as a tool for neighbor disputes. So a lot of times you'll have a violation brought to you by a neighbor who may be in dispute with their other neighbors. So we have had this happen before with whole neighborhoods. So you can expect this might happen at some point. But a lot of violations will be brought to you by complaints from other people, but there's a lot of different ways that you'll discover violations. So we will go through the more common ways that that can happen. But violations can cause contention. People can get emotional in general when they don't want to comply or meet with you, or it gets expensive, that kind of thing. So just be prepared to deal with emotional people. It's kind of like recovery in that way. So a violation is development that has occurred within the special flood hazard area that does not meet the minimum requirements of the local floodplain regulations. And so one of the minimum requirements is to have a permit. So anything that has been done without a permit is considered a violation. If it's not meeting the minimum standards as well, it could be vulnerable to flood damage if something's not built high enough or with the appropriate materials. It can make insurance more expensive, and FEMA could potentially impose sanctions on the community through either probation or suspension. Development is any man-made change to improved or unimproved real estate that includes but is not limited to buildings, modification to existing buildings, flood control systems, so any mining, dredging, filling, grading, and paving. So that means replacing a driveway, anything even up to routine maintenance, really anything. So any man-made change constitutes development and is supposed to have a permit. So there are some activities that are not likely to cause an obstruction that you can exempt from needing a permit, but those need to be explicitly exempt from the permitting process in administrative procedures. And so there's just very few things that you can exclude that are not going to cause an obstruction, but that'd be something to put in your administrative procedures so that you know that people are not committing violations, you're not documenting it that way. You're allowing for routine maintenance and tiny improvements like mailboxes, flagpoles, that kind of stuff. So if it's not explicitly excluded, it's supposed to have a permit. So, and this list is not all inclusive. Like I said, any man-made change. And so doing the outreach and making sure that people are informed is really the first step to avoiding violations. A lot of them happen because people don't know they need a permit for certain things. And of course, special rules apply to the floodplain. So people are not always aware that a separate floodplain development permit is required and has its own set of rules in your adopted ordinance that is unique to those areas of floodplain that you don't have in the other areas of the community. So doing outreach, having signage like this, really signage anywhere you can put in your community, in public buildings, city buildings. You can do pamphlets. There's a lot of different ways to do outreach. You can do periodic social media posts, but really I would think if I was a local floodplain administrator that I would try to do annual certified mailings if possible. So you should have a list of communities, or sorry, a list of addresses that are in your community that are in the special flood hazard area. That's important information to have in case there's flooding. But also you could do annual outreach on the need for permits, the type of development, standards that they would need to meet depending on the type of development they're doing. So you could have a brief overview of new structures, substantial improvements, accessory structures, the most common types of improvements that you would see at those properties, and then just make sure that they're aware that they would need a permit, or they can't really say that they weren't aware if you're doing that. And that will help you avoid violations where at least people just didn't know that they were required to have a separate permit for that, or whatever the case may be. You can also reach out to local businesses if this is an issue for you. Sometimes these businesses will provide accessory structures, and if it's a low-cost accessory structure in the special flood hazard area, it can be built at grade if it's equipped with flood openings and it's made of the appropriate materials and it's anchored and all of those standards that are in your ordinance for accessory structures. And so these are often purchased and then just delivered at a property without those specifications. And so if you have a business like this in your community, you can at least do outreach to them so that they're notified that addresses in the special flood hazard area have certain standards for their accessory structures that they're supposed to be meeting. Or any business like this that may be causing issues, at the very least, if people complain that they were provided in the way that they were delivered, then you can at least tell them that they were notified that there's areas of floodplain and that they should be meeting these certain standards. So a structure of any size can become an obstruction and or debris if it's not properly anchored down, and it needs to have a permit and cannot be exempted from permitting. So I have had some communities tell me that they don't permit accessory structures below a certain size. I've had a few communities tell me that. And an accessory structure is not something that can be exempted, like roof maintenance or replacement of a driveway or something like that. A structure of any size would need a permit and to comply with those regulations. So I just wanted to throw this in there in case that comes up. So what gives you the right to manage the floodplain and enforce violations? So we have a number of state laws that apply to this. So first, your locally adopted floodplain regulations. As part of the National Flood Insurance Program, you are required to enforce all of those regulations. And those are granted through the state in various statutes. So if you do look at these, and many of them are cited in the state model ordinance where these are applicable, you have specific floodplain regulations there in the Kansas statutes. Again, those are cited in the ordinance. Administrative regulations, there's laws on dangerous structures, KDHE. There are other state agencies that have rules about floodplains, specifically KDHE, and mostly septic tanks is addressed in Bulletin 4-2 that they're not supposed to have septic tanks in the 100-year floodplain. That is apparently being updated. Minimum housing codes, insurance proceeds, which I'll go over, and then abatement and special assessment. So something that is often misunderstood or just missed by communities, and that was confusing to me at first, is that when you join the National Flood Insurance Program and adopt regulations and adopt your floodplains, those become basically their own zone. And so that's why the Kansas zoning laws apply. So even if your community itself doesn't have a zoning ordinance or have zoning department, you don't do it that way. You have a standalone ordinance. It's still considered a zone, and the Kansas zoning laws apply. So I just wanted to explain that because communities are sometimes confused why we treat it as a zoning violation, because it is a zone. So whether or not you have zoning in your community, it still applies. So that's why all the publication requirements for a zoning amendment apply to any change to the ordinance, and so on and so forth. And then we at the state have our own stream laws that are a little bit separate from the National Flood Insurance Program, and apply to stream obstructions and floodplain fill. And so those are separate violations that we enforce. And that's the only kind of enforcement that we can do in a community when it comes to floodplain violations, but I'll get into that a little bit later. Another thing I wanted to point out is KSA 12-758. So this gets brought up sometimes that people believe that agricultural structures are exempt from any kind of permitting. And I just wanted to highlight that it says, except for floodplain regulations, that agricultural structures are typically exempt from zoning rules. So not in the case of floodplain. Like I said, any structure that's in the floodplain has to be permitted. Specifically, those are kind of the most important thing that we look at as far as development. Okay, so the insurance proceeds ordinance, now I haven't come across any communities that have adopted this, at least that I know of, at least not through us, but we do have model language for this. And so the insurance proceeds are rules that you can apply and adopt, where you can withhold 15% of an insurance payout of part of their claim. You can withhold that until they bring their structure into compliance. So this is another tool that we have. Again, I haven't seen it in use as far as I know, but basically the city will withhold 15% of that claim until it's brought into compliance. So that's probably a decent enough incentive to get someone to comply, and it's just another tool we have, but I have not seen it in action. So if you do know that you have this adopted, or if you've seen it be used before, I would be interested in hearing about that. But we do have this available in case you didn't know that. So when does the enforcement process start? Is it when FEMA notifies you of a potential violation because someone applied for a letter of map change? That is something that does happen, usually with the Lomar F application. If they see something that may have been built out of compliance with at least the FEMA minimum standards, they will flag that and then ask us to work with you on resolving that, or at least investigating that to determine if a violation has happened. So that's one way you might find out about it. I usually volunteer to work with communities directly rather than have them work with FEMA. I'm your go-between person between you and FEMA. When an anonymous complaint comes in, or maybe it's not an anonymous complaint, it could be a neighbor complaint or some kind of complaint from someone in the community. When you visit the property, or when you see something in the floodplain that you know has not come across your desk for permitting, or is it when we do an audit of your floodplain program? It's kind of a trick question because it's all of the above. As soon as you become aware of a violation or a potential violation, we need to start looking into it. We can't just rely on complaints. Violations can be anything, anywhere in the floodplain, so we need to keep an eye on development. So I recommend just visiting your areas of floodplain, the addresses or the areas that you know are in your special flood hazard area, and just periodically look for any development that you know hasn't been permitted, or that you need to look into it as to whether you permitted it or not. just trying to keep that awareness because it's not always going to come across your desk immediately. You might not find out about it until someone's applying for a certificate of occupancy or something like that. And we don't want it to get that far before we discover it. So just keeping an eye on those areas is a good way to avoid expensive violations. So we have heard a lot of communities that don't want to enforce their regulations for various reasons. So we can go through these. Why should I worry about it? If banks are making people buy insurance, the banks are doing the floodplain management. They certainly are not. Banks have to comply with the mandatory purchase requirement. So if they have a federally backed mortgage in the special flood hazard area, they are required to carry a policy. It could be a private policy or an NFIP policy, but they do have to comply with that. And they often have a third party company that does those determinations. And so they're really more on the insurance side of those requirements. It really doesn't have anything to do with enforcement of the regulations or following those. That is on the floodplain administrator to ensure that they are in compliance. So the banks don't look at that, although a violation could impact the cost of their insurance premium. I'm too busy. That one, it comes up quite a lot. It's usually like the person just was unaware that they were the floodplain administrator, or they just haven't gotten applications because people are building without applying for them, et cetera, et cetera. And many of our floodplain administrators have 3 or 4 different jobs that they're doing. And so it can be a time constraint, but floodplain management is definitely one of the more important hats that you wear, especially when we do audits and then we have to enforce violations long after they've happened or a couple of years after they've happened. That makes it a lot more difficult. So making sure that floodplain management is at least, one of the important duties that you have. You don't want to upset anyone. Of course, this happens a lot. Like I said, people do become emotional when they're told they're in violation or that they have to bring something into compliance, or again, if it's part of an ongoing dispute. We are required to enforce the regulations anyways. I know there can be some political stuff that gets involved as well. But you can always rope us into it. We're happy to back you up as far as, yes, you are required to enforce the regulations, and this is what the ordinance says that you have to enforce. So of course, copy us on all your correspondence regarding violations. We're happy to help. And you can always say that we became aware of it and that we're part of ensuring that you are doing the enforcement. So we're kind of like making you do the enforcement. You can kind of offset a little bit onto us. Just let us know if we're gonna encounter someone that's upset, so that we know how to approach the situation. But we're always happy to help. It's already built or it's done, so it's too late now. That doesn't really apply. It's just a lot harder to correct a violation once something has been built. It's a lot more expensive to elevate a structure that was not built high enough. So that's why we want to do inspections during construction. We want to keep an eye on the floodplain so that we can stop things before they've been completed, so that we can correct them before it becomes a much bigger problem. Because the longer things go on, the harder it is to fix. And so we want to be proactive about preventing violations rather than trying to fix them after something has been built. But even if it was built out of compliance, we're still required to enforce the regulations and correct that violation. The violator is the mayor's brother. So this happens a lot, where the person is on the city council or is a prominent figure of some kind in the community, and then again, the political part comes into it. That can make it difficult. We have had quite a few situations like that. Of course, we're still required to do the enforcement, but that can make it harder. Again, if you want to bring us into it, we can help maybe offset some of the blame, or if someone is considering you at fault for enforcing things, we can maybe help with that. DWR is allowing violations in the floodplain, so it's our fault. So we can't manage the floodplains. I mean, we're overseeing the entire state, and we're not authorized by your community to do the floodplain management. The ordinance names who that person is, what title in the community that is. So we're not the floodplain administrators for any community. We just help floodplain administrators, and we do other activities that support floodplain management, but we're not authorized by your community to enforce the regulations. That is whoever's named the floodplain administrator. We don't do that here, or we don't have procedures in place to do that. I have heard this one. First, the floodplain ordinance does have the procedures, at least the bare bones procedures on how to do that and what the requirements are, and we don't do that here. So if you're in the National Flood Insurance Program and you have areas of special flood hazard area, then you're supposed to be doing that there, and you do have adopted procedures, and you should have written administrative procedures on top of that that kind of flesh out what those processes look like. So that's definitely one way to get on our auditing list. We have a community that will be doing that with this year, just because they don't have a permitting system and they were not concerned with permitting and told us that they would not be doing that. So now we have to start the audit process on them. So there should be something in place. You should know where your ordinance is, or work with me on updating it. But yes, those procedures are in place, at least officially on the books. So the permitting should be happening. Or I'm protecting my community from FEMA by not enforcing FEMA's rules. You're doing the exact opposite if you're not requiring people to meet the performance standards in your ordinance. The rules are in place for a reason, to ensure that things are reasonably safe from flooding. So if you're not doing that, then things are vulnerable, and the community could potentially be held liable for that if something were to happen. If someone were to be injured and loss of property, if it ends up in court, a community official or the community could potentially be held liable for not enforcing the rules. That would be an extreme situation, but we have had situations where they weren't enforcing the elevation requirements, and then eventually the city ended up having to pay to elevate an entire neighborhood of houses. And you definitely don't want to tell the city council that. Or it's, quote, not in the floodplain. I think this has been clearing up a little bit more as we have digital firms. We also have digitalized most of our paper maps. If you're not in a current flood mapping project that's ongoing, we do have that layer on our flood hazard viewer or effective floodplain viewer. So it's been a lot easier to clear up those claims rather than when they're on paper maps. So if there's a dispute on that, we can at least look at the map and make a better determination. But if the map says it's in unless it's taken out by a letter of map change. So when we're starting to look into a potential violation, again, no matter how we've received it, we should start looking at aerial imagery and start making maps. So of course we want to verify, first of all, is it in the floodplain? If it's not in the floodplain, then that resolves the issue as far as floodplain management goes pretty immediately. So we want to look at the map, see if it's actually in the special flood hazard area. It could just be that it's right outside of it and you have special flood hazard area on the property. That happens. We want to start with a violation file. So we kind of have to go back to the office and maybe do a little bit of homework first before we determine if something is a violation or not. And then we want to make sure that we're documenting everything as we go through. So again, starting a violation file, we want to document everything as if we're going to court. So, overdo it, document everything. We're going to go through the inspection process here. We just want to make sure that in case something goes to court, which is basically the most extreme end of the road consequence that can happen, that's the maximum extent possible for enforcement as far as FEMA is concerned. That's what they consider the maximum extent possible is going to court. So we want to document everything, of course, verify if it's in the floodplain. If so, who owns it? You might want to make a supplemental map, parcel map, tax, property map, supplemental maps. So you can make a ferment, and then you might have like a location map through the community. So when FEMA finds a potential violation before they ever even reach out to us at the state, they create a detailed file with all of the documentation that they can find. So they have the flood map, a location map, maybe history that they have on that property, any correspondence, any sketches that they've been submitted as part of that application. They put everything together before they even contact us at the state or ask us to reach out to you. So we get those files and we're able to evaluate everything that they're alleging may have happened as a violation. And then we start working with the community to hopefully resolve that and do some more investigating. So as you're enforcing this in your own community, you should start putting together all of those types of things because sometimes maybe something was built when there was a different map that was effective, and so it's been grandfathered in and it's not a violation. That kind of thing can happen, so we want to go back and look at some of those things before we contact the property owner. Aerial imagery is a really helpful tool. This is what we use when we start a floodplain audit. In addition to the other aspects of the floodplain program, we will look at aerial imagery over the last couple of years. We look into about the last 5 years and just try to look for new development. So this is an example. So you can clearly see that a new driveway or like private road has been put in and a new structure is there. So if something is hard to see or is too far to be able to access from a public vantage point, then you may want to use aerial imagery just to help verify that there's been change that you're seeing. So these historical photos are very helpful. We use Google Earth Pro quite a lot, and they have, the different imagery that's available depending on where you are. I also use this. If you just type in Wayback Imagery, you can pull this up. This is part of the Living Atlas on ArcGIS Online, digital archive. And this resource has pictures that Google Earth Pro or like Google or other search engines don't have. So that's why I just put this in supplementally. Like if there's like a gap in years where I can't find a certain time period, or it's just way too far back, then I sometimes go here and at times it will have that imagery that you can't find via Google. Of course, reviewing your previous permit files, building permit records. So again, we're going back to the office and maybe doing a little bit of homework before we head out into the field. And then you can kind of look at previous permits. Maybe you have cumulative improvement and now they've done something that constitutes a substantial improvement or whatever the case may be. You might have appraiser property tax records that will have dates where additions were put in or other records of construction. Again, map changes, you might need to look at a previous map or something, and that could potentially resolve an issue. So it just depends on what you're looking at, but going back and seeing what information you do already have on that property is a good place to start. And then when you are going into the field, so you do believe there's been a violation and we need to maybe take a closer look at that and see if we can, from a public place, see what's going on. I will talk a little bit more about entering property and getting permissions, and we do have that written into our state model ordinance. So if you do need to do that, there's a proper procedure for doing that. Definitely don't just enter private property, though. There's a process to that so that we don't violate the Fourth Amendment. So we do want to get a good establishing shot. So this, in this scenario, is the potential violation. We have an accessory structure here. From what we can see at this angle, we don't see any flood openings, so it could be a violation. So this is a close-up of that, but we also need an establishing shot. So some pictures that show us exactly where we are that can't be disputed as far as location. So yeah, property owners, when they're caught with a violation, they may try to get out of it in various ways, like lying about what's there, what property they own, what's been going on. So that's why we have all of these things to hopefully back us up when we're trying to address a violation or potential violation. So what we want to do is get some landmark things. So we have a fire hydrant in this picture. Again, we're on public property. We haven't entered anyone's property. And house numbers are a good thing to capture, and any other distinguishing features that will establish where we are. So this is an establishing shot. Wide angle photo captures much of the property as you can. We want to use unaltered photos and raw unedited images just so that we have that metadata in case it ends up going to court again, just in case we want to document everything. So having that metadata will help you. So a street sign is a really good landmark. It's very clear we're on the corner of State and Village in this particular shot. So we're documenting this. There's a very distinguishing red door, and then you can see in this photo they have been flooded and there's a lot of their belongings out on the yard. And so, this would be part of documentation for a substantial damage assessment. It's very much the same for a violation inspection. So having those landmarks are good for establishing the property, and then people can't really dispute what's been observed from their property. So where we stand when we're taking the picture, people again get emotional, they could get defensive and argumentative. So what we want to do is stand on public property, because if you stand on the curtilage, so this is any area surrounding the property, including the driveway, the front lawn, anything that's actually part of that property is considered curtilage, and it's protected the exact same way as the inside of their house. So if you start doing an an inspection, you want to stand on public property until such time that you've secured permission or you've gone through the notification process to enter private property, because otherwise they can consider it like you're doing a B&E, breaking and entering or trespassing. So we don't want to cause any additional issues. And people will absolutely say that you're, trespassing, you're on my property, you're violating my Fourth Amendment, which is unreasonable search and seizures. So we do have to be careful about this. It's the same with police. They can't enter a house without a warrant or permission. So it's similar in that way. So just, we don't want to create additional issues while we're trying to resolve something. So beware of the curtilage thing, and then go through your procedures for getting permission or notification to enter private property. And this goes back to the Boston Tea Party. So you have the Stamp Act. So you had tariffs on all the goods that were being imported, and you have stamps on everything that's been paid. And then they were increasing the prices, and then that money was used to pay British soldiers to enforce that by breaking in and doing searches for unstamped goods, which led to the Boston Tea Party and, part of the revolution and all of that. So that's where this stems from, the warrant and everything, that people have a right to not be unreasonably searched in that way. So people will definitely bring up the Fourth Amendment in that way. So we just want to be careful about that, and do things according to due process and the procedures that we've outlined in our ordinances. Um, right. Of course, there's a safety issue, and we'll get more into this. I have been approached and followed by people when I was not even on their property. I was, outside of it on the public property taking pictures, which is perfectly legal, but people will, get a little bit upset about that. So definitely don't trespass. People can get a little bit overboard with it, but safety concerns, we'll go over that a little bit more in the second hour. So again, house numbers, staying on public property. So we can ask them like, hey, is this your house? The house number is right here. You would recognize your own home. So then you go back. So this is your house. We can see a shed here. Here's some aerial imagery. It wasn't here last year or 2 years ago. And so then we can ask about that. When did you put the shed in? Does it have flood openings, et cetera, et cetera? So we can lead up to it in a way that there isn't a chance for them to kind of try to weasel out of being the property owner and the violator or potential violator. So again, the close-up shows a lack of vents and anchoring. From whatever reasonable vantage point we can get these photos from. Again, we don't want to enter the cartilage, and we don't want to violate anyone's reasonable expectation of privacy, and we'll get into that a little bit more. Again, you're going to go back to the office, do some homework. Do we have a permit on file for this? Do other departments in your community have a permit for this? And we're going to save the metadata so that it's unedited raw data in case we have to go to court. And we sometimes talk about just having a cheap camera. You can get very cheap, high quality photos with a digital camera just to have in your office. I have one here that I use just in case this ever gets confiscated. You probably don't want to keep it on your phone or something like that. Like if the property owner is making claims that you've altered photos or something, they may want to see the device. So you can have an inexpensive camera for around $100. I don't think memory cards are very expensive anymore either. And then you can have all of that data saved onto the camera, and it's not very expensive. And you're not going to lose your phone or something if it gets a little bit more serious. Okay. So take multiple pictures for sure, get your establishing shots. Digital pictures are free. We can take lots of them in this day and age without any issue. We don't need film anymore and stuff like that. So again, court is the end of line for all of the enforcement process. So in case that happens, you want to work with your attorney. Of course, work with the attorney on any enforcement action, but definitely let them look through the pictures and choose which ones should be, used in court. You don't need a selfie stick. And then of course, save the metadata because that might be important. So go through the photos with them, explain what's good or bad about it, and then just let them choose which ones to use. Okay, so privacy fence, and back to the Fourth Amendment issue. So we talked about curtilage, the outside area of a house. There's also a reasonable expectation of privacy when you have a privacy fence. So, reasonable expectation of privacy. So we're not going to go up to it. We're not going to climb on the fence or touch the fence or try to take pictures from between the slats in the fence. This is appropriate, these vantage points. So we're on public property, we're on a sidewalk, or we're in the road or something, and we can see development. So we can see that there are sheds or some kind of accessory structure in the backyard without violating their reasonable expectation of privacy. So if we can't see it from a public place, if you can't see it on aerial imagery, it might be more difficult to do enforcement if they're not being cooperative with you. So, I mean, the ideal situation is you can talk with them and get voluntary compliance. Oh, I'm sorry, I didn't need a permit for that. And they fix everything, and that's fine. But it can be difficult if they're not cooperative and you can't see it from a public area, and then you'd have to enter the private property, and we'll go through that. Um, so the privacy fence is that they have a reasonable expectation of privacy. So don't raise the camera over your head. Don't approach the fence. Don't get off the sidewalk, I would say. Definitely don't use a drone. So if you can see something naturally, like in the last slide, that's fine. But raising the camera it shows an intent to violate the privacy, and the intent is what's important here. So again, the illegal search and seizure thing, you could capture potentially people or property owners in the photos, which could definitely cause additional issues. Drones are kind of on the newer side of technology, so it's a little bit unprecedented as far as its use in the court system. So there isn't, I don't think, so far legislation regarding that. But again, the intention to violate someone's privacy is where the issue lies. So you can't really use a drone to take violation pictures. I mean, that would probably make it easier, but again, like privacy and people's rights and stuff like that. So we shouldn't use that to investigate a complaint. It's kind of like helicopters have certain height requirements for this reason, in regards specifically to privacy. So it's sort of like that. Whereas this example was given, if someone, a city employee, was fixing a broken streetlight and happened to see ongoing work in someone's yard, that would be okay because the intention was not to violate their privacy. They were trying to, repair a streetlight. So again, the intention is what's important for that. So just keeping that in mind. And then again, document everything as if you know you're going to go to court. Again, most situations can be resolved without going that far. Just having good records are important for when things like that don't work out. Record keeping is extremely valuable. If someone complains about you, that you've been doing something inappropriate when you're just doing your job, looking into potential violations. So having that, documentation, definitely working with your other community officials as far as what's required, what you have to do to enforce violations, and making sure your other important departments are on the same page. It kind of goes with the permitting procedure, the enforcement procedure. If there's any other departments that might be involved with that, that you have that open line of communication and that they're aware of rules and why you might be doing something, so that they know you're not doing anything wrong, you're just doing your job. But yeah, keeping those records as well. And then of course, being consistent and doing the same for everyone. Just having those procedures outlined in your written administrative procedures can really help so that you have a consistent system to follow. Again, if someone complains about a neighbor, that can open a whole can of worms. We had that happen a couple of years ago. The entire neighborhood was in the floodway, and then someone complained about a detached garage that was built on someone's property, and then everyone started complaining about everyone else, and then everyone had to get no right certificates. So it was very messy, and that can happen. So we can look at a couple of things here. Is this a violation? It's clearly a violation. It's not made of flood damage resistant materials. It's not anchored. It's not, there's no flood vents on it. It's kind of just thrown together. So it may be a violation from a couple of different departments. So again, that's why it's important to communicate with them. So this most likely does not have a permit, or at least it shouldn't have been permitted in the way that it was built. And is this a violation? So in this case, this shed was added here like in the 70s. It's over 40 years old. And so it's not anchored, it doesn't have flood vents, but it was added before the firm. It's a pre-firm structure. And so it's actually been grandfathered in, and it's not a violation until it's been substantially damaged. And then if they wanted to rebuild it, it would have to come into compliance, which would probably mean a new shed that meets the current requirements. So that goes back to doing a little bit of homework. How long has this shed been here? Is it really a violation, or it's just been grandfathered in? Again, do the outreach. That will help you avoid violation. And we do have other classes on just permitting and substantial damage where these things kind of overlap, just so you're aware. So then when you have a violation that you've documented in some way, you've done the investigation, you've done a little bit of homework on it. First, we need to work with the property owner. And again, hopefully what we have is voluntary compliance. So if you find ongoing construction that has not been permitted in the special flood hazard area, we can issue a stop work order. So this tells them to stop until there's been a permit. So from what I've been told, you don't need a special form, and this can just be done on the community letterhead. I have not really seen this in action. Like, I haven't talked to anyone who's issued a stop work order. So if any of you have information or you've done that before, I would appreciate the information. You can, just let me know at the end of this, or an email, or I send out another survey, but I would like to know more about this. But you do have the authority to stop ongoing work if it has not been permitted, especially in the floodplain. And like I said, it's easier to get compliance and correct a violation if it hasn't been finished yet. So this might also be good for them to stop and then correct something, get the permit before continuing work. So you don't want to delay this. You want to do it as soon as possible, as soon as you realize something's been going on. You issue a stop work order and get that into compliance. So right, that should be issued if there's construction taking place, or the violator needs to be noticed of the violation somehow. We suggest using certified mail with a follow-up mailing affidavit. So this is part of your paper trail, your documentation that you have in case things go to court. You have documentation that you notify them of a violation or potential violation, or an alleged violation, because we call it a letter of allegation, which I'll get into. A mailing affidavit might be better because sometimes people will not sign for certified mail if they're expecting some kind of bad news. A mailing affidavit may be better than a certified letter in that case. So this is kind of what it looks like. The notary public will witness you mailing the letter. It can be cheaper and maybe a little bit easier than certified mail. And then the property owner can't really claim that they never received it. I don't know. You have a couple of different options. I think certified mail works as well. So we start with kind of a nicer violation letter. It's a letter of allegation. We think you might be in violation. You might have something on your property that looks like it's a violation. So the location and nature of what it is, make it clear, reference where in the ordinance these standards are that it might not be meeting, where they can find a copy of the ordinance online or at City Hall, or both, what sections were violated, informed of the possible consequences that could happen if it's a violation and they don't correct it in a reasonable time frame, informed of the desired response or action to be taken, usually meeting with the floodplain administrator, or bring it into compliance, like your accessory structure needs flood openings, etc. And we try not to make it too technical. We don't want to use jargon or acronyms. We just want to spell it out very clearly what the issue is and what they need to do. We're trying to generate action with this letter, and we're not, being too aggressive. And so this can work magic sometimes, an alleged violation. We can't locate a permit for it. So it kind of lets them know if they were somehow unaware that they needed a permit, that they should come and fix this. Again, voluntary compliance is the best outcome. Or some people will just remove the violation entirely. And then the problem has resolved itself in that case. So where do you send the letter? The owner of record of the property, so you can check with the Register of Deeds on who that is. You can request a limited certificate of title through the attorney. That covers the history of ownership. The person that's living there could just be a tenant or a lessee or something like that. So we want to get to whoever is the responsible party for the ownership and maintenance and any violations there. And again, you have a couple of different options for mailing that out. A street address may not be enough information. You probably want to give the parcel ID and the legal description in that letter as well. We'll go over the different parts of what goes into the letter. Again, renters versus landlords, who created the violation? The landlord is typically responsible for fixing it. Whether the renter did it or they did it, they need to get that fixed. And they can deal with the tenant if the tenant has been the issue. And then we could potentially abate something. So basically, you pay to have it fixed, and then you have that lien on their property. So they end up paying it in property taxes. So we'll go over that a little bit more. If you're having issues trying to find the person, you can find their representative agent, who's not the owner, but they're authorized to act for the business and to receive mail. So you can find that on the Kansas Business Center if you're having a hard time. Okay. Oh, so it just kind of lists that. So a violation letter is like a BLT, so you have these different layers to it. So you have an opening greeting, so they know who you are. It's addressed to a specific person. It's not to whom it may concern. You need to put a specific name on that letter. You explain the violation. It looks like you have an accessory structure on your property that's not meeting our community ordinance requirements. You can find the requirements here. The citation is that it needs to be properly anchored, made of appropriate materials, has flood openings, etc. Can we meet to discuss this? Let's just sit down and talk about it. Explain the possible consequences, the right to appeal, which basically means apply for a variance, and then maybe go into a little bit about what a variance is and what's required for that. And we'll talk a little bit more about variances in the second hour. A deadline, it's usually 30 days is enough for them to respond. And then a conclusion, definitely all of your contact information. So if you don't talk about variances, or at least something to the effect of their right to appeal, it could be a denial of their rights, a denial of due process, that kind of thing. So definitely want to mention that they have a right to appeal your decision. So your ordinance also lists a board of appeals, who are the individuals that are authorized to appeal your floodplain management decisions. So that could be, usually we're referring to variances in that case, and we'll talk about that more, like I said. And then again, a deadline, give them some kind of time frame to work with. Otherwise, people will put it off. And then we kind of use this as an example of a not so great letter. So again, you have these different layers here listed on the left side, and then this is our bad letter example, and then we'll look at some of our templates for hopefully what's a good letter. So this one is addressed to whom it may concern. So again, we want a specific name in there. As of now, you are in violation in all caps of community floodplain management regulations. It doesn't say why they're in violation. It doesn't give the citation to be able to continue work at the property, and it gives that information. etc. So you're in violations in failure to comply with the requirements of our resolution. So at least it gives the resolution number, but it doesn't say what section of that is in violation or why, what the violation is, where they can find the resolution. It's just, it's very aggressive and it doesn't give any details. Yeah, so it just says that this is a misdemeanor, and then it's like threatening to be to use the fines that we have. So I mean, having a fine in the ordinance is something that we do have that does help get compliance, but we definitely don't start out this way. Again, it's an allegation letter. We try to do the soft approach before we get into anything more serious. So it's just kind of very threatening, aggressive. It doesn't give very much details. And then it kind of goes into, if you're not in the floodplain, then get a LOMA, which is kind of a weird approach. And a LOMA is something that we can use to resolve a violation, because if you have a LOMA, you've been inadvertently included in the floodplain when you shouldn't have been, and FEMA corrects the map free of charge. So that is a valid avenue if they qualify for that. But I don't think that needs to be mentioned at this point. And to do this, we'll need an elevation certificate. That's not even true. There's an elevation form that goes into the application and FEMA reviews it kind of outside of the floodplain administrator. Anyways, if you'd like to read the regulations, you can find them in the office. Okay, so at least it kind of tells them where to find it, but still, I would put that towards the top with the citation and the resolution number. And then kind of the bold print underlining and all caps is a little bit much. Call the office in 30 days, kind of yelling at them, a little bit rude. So we want to be hopefully having a productive conversation and a good working relationship. We don't want to threaten people, and we don't want to use threats of misdemeanors and fining when we don't need to. We don't need to do that. Those are things that come in later as we're not getting compliance. So we start off just having a conversation and explaining everything. Request a meeting, make sure you have your contact information in there. You can explain what the potential consequences are. But we kind of want to frame it in like, we don't want this to happen to you, but this is what can happen if, this doesn't get fixed. And then all notices to the violator that requests a response or action by that date. So response due date. So you say 30 days and then you give them a specific date. So that's 30 days from today or from Monday or whatever, and give them a specific date. Otherwise, it can be hard to get to the next step. So after this, you should take a look at your violation section in your ordinance, see what provisions are set out. We kind of beefed it up in 2019 in that version. So if you have something older than that, it may not be as explicit as what we have now. And what procedures are followed for violations of other types of local regulations. So you want to make sure that you're working in conjunction and consistently between city departments. And again, that's why it's important to have that conversation, and then have the written administrative procedures that gives all the detail of your procedures, right? So this is what it looks like now. So the first paragraph goes over inspections, how you're going to do that. Again, this kind of outlines how you enter private property. Running a little bit behind here. Sorry about that, but you get permission, or it says you affix notification in a very conspicuous place on the property for a minimum of 5 days prior to entry. So make sure that you follow this for entering private property. Of course, we want to be safe, and we'll talk more about visiting properties a little bit more in the next hour. So having all the documentation as far as them providing a permit and an elevation certificate, et cetera, whatever's required for that. Violation notices, how you're going to notify people that they're in violation. Fines and consequences is number 4. the $500 maximum for fining, but each day can constitute a different violation, so that can add up potentially. We don't usually get that far before we get compliance. And then abatement. So again, you can look in the Kansas statutes about abatement. Basically, you will pay to alleviate conditions that are a nuisance, that are dangerous, that kind of thing. That's what the abatement laws are. And then you put it on their property taxes on their property as a lien, and then they end up, being charged for that service. There's a little bit more about abatement. Number 6 and then number 7 kind of goes more into like what the lien looks like and stuff, and how the city pursues collection of that money, etc. So it's very hopefully laid out in a very concise and easily understandable way. So again, 5th and 14th Amendment have the due process language. So citizens expect due process, we give them due process. We have that 30 days to come into compliance. We give them another 30 days usually for the second violation notice. And we'll go through that a little bit more. Alleged violators have to be given due process, which is the reasonable opportunity to correct the situation, reasonable time. Send a minimum of 2 written notices before proceeding on to more harsh actions such as fines or litigation. Of course, work with community officials, especially leadership and the community attorney for sure, making sure that they're on board with your enforcement actions and the process that you're using so that you don't end up, getting in trouble with them while you're trying to fix something with a property owner. Failing to inform them that they have a right to an appeal could be considered taking away due process. So that's an important part of the violation letters. Like, you can appeal my decisions with the appeals board. So the Supreme Court says that the 14th Amendment prevents state governments from infringing on the right to privacy and having the due process and all that. So again, 2 written notices, give them an appropriate amount of time, and definitely don't do any of the trespassing stuff that we were talking about earlier. So definitely copy us on any violation letters that you have to send out. Again, we're happy to back you up. Like, yes, they do have to enforce this, or we can, spin it to where we found the violation and then we were asking you, and now we're following up with you and making sure that you're doing the enforcement, so you can kind of offset. I don't know if blame is the right word. You can just like offset that responsibility a little bit, just to, maybe take the heat off you a little bit if that's becoming an issue. So this is the allegation letters that we do have. Yeah, so this is the first one on the left. So the letter of allegation, what we hope is a good letter here. The property address, owner name, parcel number, dear so-and-so. Please be advised that an anonymous complaint was received alleging conditions in violation of such and such ordinances and codes located at this property. So the violation is alleged to exist on your property. And then, so we describe what the violation is, allegedly, and then the potentially what section has been violated in the ordinance. So we quote that, you cite what that is. Fill material placed in the floodway, something like that, whatever the issue is. And then you can, describe all of that. And then the letter is an alleged violation and direction to correct that. Our office was unable to locate a permit. So that's something we added because there have been instances where a permit was just filed incorrectly and they did have a permit. So we're like, we didn't find a permit. And it's required for all floodplain development. If this is an error, just let us know. We'd like to conduct an inspection at this particular time. So you can also add in the inspection component of this. So we have like some suggested language in there that you can add in. Well, it's just nice to let them know that we intend to do an inspection. Again, at the very least, we've done the public property inspection where we have not entered onto the curtilage or anything. So then it kind of goes a little bit into what could happen. We'll initiate enforcement actions, inspection fees, abatement fees, administrative fees, criminal prosecution, etc. This is your only warning, so it's still very like respectful and just kind of in the hypothetical. And you can avoid this by correcting it, by applying for a permit or discontinuing the alleged activity, etc. Reach out to us. We'll work with you. We'd like to meet with you. If you have questions, let me know. So it's very like respectful and just kind of, again, alleging a potential violation. The second letter is where you can get a little bit more focused on what the consequences are since they've already been notified, and they've been given a specific amount of time and a specific date to respond to you by, and then you can send a little bit more of a intense letter. And I think I may have actually put the same letter here twice, which I did not mean to do. We have another template that's for the second notice that again is a little bit more focused on the consequence part. And that way, it's just a little bit more, aggressive, if that's the right word. It's just a little bit more, we're not letting this go. There are consequences, and we're going to start doing the enforcement actions if you don't, comply or speak with us at least. Actually, this might be the right one. So this one kind of says it a little bit differently. It does have a little bit more of like the bold type and the underlining. And so we do have tips on writing violation letters, and then we have template violation letters. So that's on our website. I can also just send them to you if you want. And of course, you can rope us into it as well. Like you might end up needing to speak with the Division of Water Resources, and they're also monitoring the process of this violation. And if they want to reach out to us, sometimes that helps. Like they'll give the property owner our contact information, and then we'll speak with them and pretty much tell them the same thing that you're telling them. And then, it might help move things in the right direction, potentially. And then, of course, if there's a stream obstruction violation or a floodplain fill violation, then that is done through us, but that's in violation of those laws that are separate from the NFIP again. So again, copy us, let us know what's going on. We're happy to help however we can. And then, like I said, we have regulations that are not the same as the NFIP, and we have to do a separate enforcement process on those. And that's through our Manhattan office. I think that it helps probably with resolving an NFIP violation if they're also getting a DWR letter. So that's not through us, that's through the stream team. We're on the floodplain team, but maybe that could help. And of course, that's floodplain fill, any obstructions, channel changes, that kind of thing, those have to be permitted. And it might be a core violation in that case. And we've had other entities that have had to get involved, like the EPA when there was a wetland violation, or KDHE sometimes has an issue if the person is violating, multiple agency rules in addition to the floodplain. So doing the inspection process and then sending those notices are your first steps. Doing the homework, getting that documentation together, starting your violation file. Then you meet with the property owner, hopefully. They're going to cooperate with you. They're going to respond. You come up with a resolution. Like, yes, I can move this structure. I can install flood openings. I will apply for permits, etc. And if you can't reach that stage where you have some way to resolve this appropriately, you may end up going to court. Again, that's the most extreme last step of stuff. So we'll go over that next. So you don't have to sign up for that because we're going to do it next. Resolving problems and taking an issue to court. So since we're an hour and 10 into the presentation, we will do a quick poll question and then take a 5-minute break and then reconvene. So Caitlin, if you can launch the first poll question. So I do need you to answer these if you want the continuing education credit. So there's a poll question here. When does enforcement start? When you first become aware of the violation, when an anonymous complaint comes into your office, when you visit the property, or when we do an audit. So if you want the education credits, you need to participate in this poll question, the poll question at the end of the next hour, and then have been here for at least 75% of the class time. Otherwise, I can't give them to you. And if you're not a CFM, you can also just get a certificate if you'd like. But we'll do that at the end. All right. Okay, it looks like everyone has answered, I think. So if you want to end the poll and share the results. Wait.
It looks like there
Oh,
may still be one more person who, if they want to answer,
sorry.
could.
Okay, yep. One more person. I don't think it's me. Maybe it's me. Okay, maybe.
I'll go ahead and end it.
Okay. Okay, yes. So it's when you first become aware of a violation. So however it comes across your desk, it could be us, it could be FEMA, it could be a citizen, it could be anonymous, or you just see something while you're driving through the floodplain, etc. However that happens, then you just start investigating a potential violation. So, yep, most people got that right. So that's great. Okay, so 5 minutes. Can we get back at 2:45, 2:46-ish, and then we'll do the next part. Okay. So the next part is meeting with violators and resolving violations. Again, courts is the last step to that, if it gets that far. So what is the key to enforcement? Definitely consistency. So we want to treat everyone with fairness and equality, and that will help us avoid issues. We need to treat everyone the same. And so we don't want to let any of the permitting requirements slide or violations slide because people will, complain that you didn't enforce the same rules on someone else, etc. So making sure that the same rules apply to everyone, and that's where written administrative procedures can really help, is that you have a very specific list of procedures that you're going to follow for everyone the same way. So of course we talked about due process and how to inspect and send notices. We definitely want to make sure that we're doing everything legally. So we had this one floodplain administrator who had a violation, and then the person didn't want to comply. And she went and had their water shut off just to get them to comply with the rules, which was just storage of material from the front yard. And I don't think the notification process was done either. And so that could have ended in a lawsuit. It did resolve the violation, but that's definitely not the right way to go about it. So again, administrative procedures will go through how to do enforcement, and it gives you a template to follow each time. You just fill in the blank. It's a little bit too much to fit in the ordinance, and it's a little bit specific and a little bit, not just strictly what the regulations are. It's your process, how you're going to investigate, how you notify, how you work with other departments, how you might issue a stop work order, or why you would do that, and how you would begin the process of taking someone to court, either in county court or district court. Some communities have a housing court, so it'll be specific to how your community is set up. And I know a lot of people just don't want to take it that far. Usually you don't have to, or sometimes the leadership is not on board with that. But either way, you'd have a set of procedures that you can follow each time. and that it's tailored to your specific community and how you're set up. So that's helpful to have. Definitely, we're not going to do anything crazy and shut off people's utilities to try to get them to comply with the regulations. So again, we want to stay safe. Like I said, when I'm doing inspections of my own to look at potential development, I have been approached or followed by people when I didn't even go on their property whatsoever. When you're going around taking pictures of stuff, people do get a little like weird about it. So, staying safe, definitely, if you can take someone with you or a group of people, wear something that identifies you as a community official. That will help a little bit if you have a shirt that you can wear, like a polo shirt or a badge, something to identify yourself with, that can help. Again, property owner hostility. People do have guns. People can act crazy. So you want to avoid secluded areas. You don't want to go off anywhere with the property owner. You want to stay, again, in a public area unless you've gotten permission to enter the property or you've followed the steps on how to enter private property, which again is the conspicuous notification on that property that you'll be entering at a certain time, etc. So if you have a good working relationship with the police force, you could do a police escort. That's really helpful. Again, if you have that type of relationship, or if it's a property owner that you know is particularly hostile to, I don't know, regulations or community officials, you might request that. Um, but at the very least, working in pairs or a group of people together. So and then meeting with the property owner. So hopefully they are willing to meet with you. Um, so you want to definitely be professional. And again, we're trying to have a constructive conversation and get something resolved and have a good working relationship. So you want to be professional, dress again, if you have a shirt like that or something that identifies you or symbolizes your authority a little bit, wear that. Definitely be on time. Watch their body language. You don't want to play the blame game, etc. So again, people are getting emotional. They can get angry. I've been yelled at in meetings. So you let them get emotional. You just stay professional and just stick to the issue. Like, hey, we have these regulations. You're supposed to comply with them. That's it. It's not personal in any way. So try and buy into a solution. Try to get them to buy into the solution, whatever that may be. Getting a LOMA if they qualify. Maybe you can look at our base flood elevation portal beforehand. I've done this with property owners and I've kind of shown them how a LOMA could work. So that works if they have an approximate lowest adjacent grade or lot elevation that's at least at or above the base flood elevation. So if you can get them to that point, that can help. Explain what needs to happen very specifically. You want to turn your phone off. If you show up late, then they can, start making it more about you being late and wasting their time than the actual issue, which is the violation. So kind of like on the psychological side, apparently like reflexive posture. So if you kind of try to mirror their body language, that might help you. I don't know. I've never really tried all of that. I just kind of try to stick to the facts and deal with people, especially if they're getting emotional. I just, kind of I don't engage with the emotional side. I just, reiterate what the rules are. Um, Again, if you've done the outreach and the education about permits, that will definitely help you. And, they would have known already before something happens, before they did anything, that they were supposed to have a permit. So that helps you. If you can get them to buy into a solution, under the legacy system for flood insurance, it used to help showing them how their premium would be reduced. That's not quite the case anymore. So we'll look a little bit at the flood insurance aspect of things, but it's impossible to tell now how anything will impact a premium. So that's kind of not as much as a tool as it was before. but it could potentially reduce their premium if they do certain mitigation um, actions that also resolve the violation potentially. Again, symbolize your authority. Um, we don't want to play the blame game. We're not getting into the emotional stuff or, any of their allegorical stuff. So I actually just talked to someone yesterday who has a substantial damaged property with a basement, and they can't get a permit to rebuild because their lowest floor is well below the base flood elevation. You're not really allowed to have a basement in the floodplain, and they were getting very, very emotional. And it can be really uncomfortable, I'll tell you that. But again, we just try to explain the rules. I try to support the floodplain administrator. Like, yes, everything they're telling you is correct. These are the rules. Here's where you can find them. And there's an important reason for that, like substantial damage. We can't let you put in investment into a structure that is at risk. So trying to explain why the rules are in place, it may or may not help, because then you might just get an earful of it's never flooded here, it's not going to flood here. If it floods here, the entire world is underwater, etc. And then I just try to explain, like, the map is the map. That's where the rules apply, regardless of whether the map is correct or not. The time to have adjusted the map has long since passed. So just trying to explain those types of rules. And people are often not as familiar with the NFIP and what the regulations are if they don't deal with it on a daily basis. So um, just trying to get that through to them. Sometimes that's all you can do. Sometimes they're not going to be happy regardless of what you say, because you do have to do the enforcement, but it's okay if they end up not liking you. Um, as long as you're safe and you don't feel like you're in danger, it's okay if they don't like you. And then explain why the community participates in the program. And no, you cannot opt out of the regulations, because this is a community-wide program where we have agreed to enforce the regulations in exchange for the availability of flood insurance, mortgages, grants for safety, etc. So as long as you get to a resolution at some point, that's the only thing we really have to worry about. And yeah, they're gonna maybe throw stuff at you like my taxes pay your salary, you're gonna get fired. So that's why you want to work with your leadership to make sure that they're backing up the enforcement actions that you're taking. And again, we're always here to back you up as well. Or we're happy to talk to property owners. I don't care if someone yells at me. You can send them my way and they can yell at me. That's fine with me. I know the mayor, all the political stuff. So yeah, again, the reflective listening, if you, much like if you try to kind of mirror their body language, if you repeat the key words and phrases that they're using back to them in some kind of a way, it makes people feel more like you're listening to them, and like you, I mean, I hope you are listening to them, just, to hear their perspective, even if it's not relevant, you're listening to them. But people feel heard and maybe more communicative and willing to communicate if they feel like you're listening to them. So if you can repeat some words back to them, apparently that is something that works. I don't know. Back into that psychological stuff. It's supposed to lead to better communication. So that's one tip that has been put out there. Um, a follow-up letter. So after you've had the meeting, it's good practice to send a property owner a letter after you've met with them. And then you can outline the full action list. Like, this is what you need to do. This is what we discussed. That accessory structure needs to be anchored. There's plenty of different anchoring systems that you can get. Flood openings, you can get engineered openings, and that will lead to less openings that you have to cut out. This needs to be elevated. It needs an elevation certificate, etc. You give them a very specific list of what needs to be done. hopefully outlining the resolution that the two of you have agreed on. And then just be sure to thank them for meeting with you in that letter, even if they were, yelling at you and they're not very happy. Still, we are still trying to be professional and hopefully have a good working relationship going forward, because maybe next time, even if they weren't happy with that, they'll apply for a permit like they're supposed to. So we want to be polite, and then no one can claim that we were rude to them. Of course, you might have other staff in that meeting with you. That might be good to have. So you want to summarize the conversation, like this is what we outlined. This is the date that we agreed on that would be reasonable for things to be resolved. I'm going to do a follow-up inspection on this date. Or you're going to apply for a permit. I'm going to make sure you're in compliance, and then that permit will be issued, etc. And then we have this written record. So we're still maintaining our paper trail of what was agreed to in writing, what was discussed, and how this was meant to be resolved by this certain date. And then you have that documentation, because again, we want to document things in case it ends up going to court. And of course, it doesn't really matter how it happened. Violators will proceed with the project without obtaining permits, either intentionally or unknowingly. So again, the outreach stuff. And yeah, some people will want to build stuff and then ask for permission afterwards. So that's where we're trying to um, monitor what's going on and make sure that people know this before they built something, and then they can't say that they didn't know that, because I have an affidavit saying that you do know that. Yes, outreach, however you can do that. Annual mailings, public buildings have pamphlets, information, social media, press releases, etc. Just, making sure that people know this. Maybe doing door hangers is a little bit much. I definitely suggest that for damage assessments, because that's when you have to go inside people's houses and do stuff like that. But I mean, door-to-door outreach sometimes is part of a mapping project or part of substantial damage. So I'm not saying it's not an option. Just making sure that you have something where you've given this information to people that live in the floodplain is what I would say. And that will help you avoid X% of it, of violations. Hopefully all of them, but of course, probably not all of them, but some of them. There are other types of violations. Sometimes people will apply for a permit and then build something differently than what the approved plans say, and that's where doing inspections during construction comes in. If you look at our template permits, our floodplain development template permit that we just finished last year, there's definitely a section in there that talks about inspections during construction and the possibility that the permit could be revoked. Incorrect site information is provided, or the site changed from submitted plans. So recently we have this rather large construction that happened where they were building very close to the floodway, and then part of the grading plans and actually part of the building ended up getting into the floodway. Where they kept trying to claim that I wasn't. And then every time we looked at the map from different angles of the aerial imagery, it was definitely in the floodway. So it's a little bit different from what their submitted plans were. Luckily, they were able to secure a no-rise certificate that resolved that. But that was one of the ones that FEMA flagged because they had applied for a letter of map change. I think it was a Lomar F. And so again, FEMA will sometimes flag those if they get an application that implies a potential violation. So, and it could be done unintentionally. They were trying to build to the submitted plans, and then something got lost in translation with the developer, and then it goes wrong, and then it becomes a violation through no one's intentional actions, but we still have to fix it. And again, elevation's not checked before, during, or after construction. It's really important when you have a new structure going in to check the lowest floor as they're putting in the foundation. And then hopefully you have either the developer or a surveyor there that can verify that it's being built at the correct heights. We've had a myriad of issues with this that could have been avoided, um, before the construction was complete. It's very easy to fix while they're putting in the foundation, to just raise it a couple of inches to where it needs to be, rather than after the finished construction. It's way more expensive that way. So that's why doing inspections are really an important part of the permitting process. It does take time to get that scheduled out, but it really helps you avoid issues in the future. So we had this happen not too long ago as well. Um, they weren't doing inspections, and then this house was built, and they were trying to get the certificate of occupancy, and they just weren't going to give it to them because they didn't build it right. It was quite a few inches too low. And then that ended up going almost to court, not quite. There's a notice on their deed. So we'll talk about the notice on the deed, which is one option when you just cannot get compliance. So not everything's going to go to court. Again, work with the community attorney, work with the leadership to make sure that they know what's going on and that they're on board with whatever enforcement actions you're taking. Um, yeah, yeah, there's plenty of examples like this. So the certificate of occupancy can really be a nice tool to, withhold that, to keep from, sometimes they need that for utilities to be connected and things like that. So we can withhold that. And that's also why it's important to work with the other building departments. If there's a floodplain issue, then they might be able to withhold whatever permitting that they're doing until that gets resolved, so that you can all work in conjunction to make sure that all of you have what you need for compliance in your different areas of work, to make sure that um, things are brought into compliance. So that's just another tool that you have other departments helping you by withholding their approvals until they have your approval, because that's how it should be working ideally, is that all departments have the routing procedures for the different permits, and that we want to make sure, especially if something's in the floodplain, letting the departments know, like, hey, if you're working on something in the floodplain, I need to see it before you approve it. And that way you have that extra tool, a little bit more leverage to get compliance. So again, our permit says it will be revoked if it's not built to plan, and it also talks about doing inspections. I may have mentioned that, but it talks about revocation of the permit and doing inspections right there. And then you have them sign the permit, of course, and then they're basically giving you permission. Like, I'm not giving you this permit unless you give me permission to do the inspections and come onto the property. So that's just another way that you have permission to enter the property, without doing the whole trespassing and Fourth Amendment stuff. We had another situation where a surveyor staked out the site for a new house, and the property owner went out and, for whatever reason, drove the surveyor's stakes into the ground. And then the contractor came and did the construction, and there was no in between inspection. They didn't come and look in when the floor was being put in, or talk to the surveyor or the developer or anything. And then this issue was discovered after the construction was completed. So again, do inspections, have that written into your permit, and then make sure you go and do that. So deficiencies in the local permit process, and we do have a permitting class that will be coming up sometime later this year. We also have, last year's recorded on our site if you have any questions about doing the permitting. And again, we have a new template. So the citizen is not informed adequately and didn't understand the requirements. Again, doing the outreach so they at least know they're supposed to get a permit, and then making sure that they understand the requirements because they should be outlined on the permit. Our permit is meant to be like a smart permit to help guide you through that process. And then you being able to explain what the requirements are to the applicant. Lack of adequate local resources, including professional staff. We do have communities that are very small, We can help you at least review the permitting stuff. So we can't evaluate the work of an engineer. It's more like, even our engineers here at DWR won't do that. It's more like an engineer puts their seal on a document. They're kind of betting their license or something that it's kind of on them that the engineering work is correct. So you can at least review and make sure that those statements are there for, no rise certificates or dry flood proofing or that kind of thing. But we can help you through the permitting process and reviewing those documents as far as making sure that the elevation certificate is filled out correctly. If they've signed off on it, then we can, for the most part, trust their work, but doing inspection is part of evaluating the work of the surveyor or the engineer. So you don't have to have that technical of training to be able to evaluate the documentation is matching up to what's actually being constructed. Um, so hopefully that makes sense. Again, we have other training that goes into that a little bit more. Again, your permit form should state that you have the right to inspect, especially at the foundation pour. That's the most important one. And does it say that the permit can be revoked if the conditions are not met or if they have given incorrect information? So again, our permit has detailed instructions. We've worked with a contractor to try to make it as straightforward and as guiding as possible. Again, if staff fails to relay the needed information between departments, you need to have that communication. Again, the permit is signed and that gives you permission to enter the property during construction. So if you find that maybe the problem was due to an ordinance or permitting deficiencies, we have a newer model ordinance. So we updated that in June of 2023. And like I said, our enforcement and violations part is pretty clear. Of course, we have to review and approve any ordinance changes or amendments or updates. So hopefully we'll review that and we'll let you know if we see anything that's could be a loophole. Hopefully a loophole or vague language would be due to a very old ordinance that has not been updated in a long time. I think our current ordinance is pretty straightforward and covers in detail what all is required for new development. Or you might need just to update your violations section because, like I said, we really fleshed that out a lot more in 2019. Or again, written administrative procedures, they don't have to be formally adopted. Those can just be an internal document that you share with leadership and maybe other departments that writes out exactly how you're going to administer the ordinance. And your permit form should act as a checklist for everything that you need. Yep. So you shouldn't have any issues with the ordinance because we review and approve them before you can adopt by state law. So put it in writing. Yeah. Again, administrative procedures, of course, put it in writing, and that way you have that consistent process for everybody. You're already attending training, so that's great. Everyone should do that. Improve communication between departments if that's an issue. You might want to update your permit application. Again, we have our template permit that is meant to be customizable for the community. And of course, you would customize it to your specific higher standards if you have that, and how that routing procedure works. You need a timely permit process to make sure that people will apply for them and have that review and turnaround time. That'd be something good to have in your procedures. And what the routing procedure is between departments. And that way people are not getting their certificate of occupancy through like the building department without having all these other things checked off. So that's, again, coordination between departments is really important. You need to be involved in that process. So understanding what your regulations actually say, so very familiar with your ordinance. You are able to access and read the maps correctly. Again, please reach out to us if you need any help at all. Understand the permit procedures and our resources. So we are having a DWR or floodplain web resources class on the 19th. So Bill Pace in our office is going to go over all the different resources and tools that we have available on our site for web resources. If you need to train other staff that's going to be involved with your permitting process, and just kind of covering any of those deficiencies so that you would know at least who to ask or refer things to. Right. Understand the requirements. All the floodplain stuff, those specific areas in your ordinance. So again, the certificate of occupancy can be like the carrot that you withhold to get compliance. That can be a really good tool. Um, that has helped us multiple times, or at least local floodplain administrators. It's helped them get compliance by withholding that until they get compliance, because again, you need the certificate of occupancy to often get utilities connected and probably other things as well. And have your inspection process written out as well. If you make a mistake, just be willing to admit that. Again, we give ourselves a little bit of wiggle room in the initial violation notification by saying, oh, we can't find the permit. And in that one example I gave, the permit had just been misfiled. So it was just a mistake on the community's behalf. But if you're, give yourself that room, like we're looking into it, but we can't find anything. If you make a mistake, then you can, apologize and move on. Ignoring violations often makes it worse. The faster you're able to take care of and resolve things, the better. So we have had situations where someone committed a violation, knew about that, was in the enforcement procedure, and then ended up selling their property without telling the new property owner. So this happened in like a period of 5 months in the example that I'm looking at in my notes. So that can happen, and then the new property owner doesn't know anything about that, and then they end up, having to correct the violation. So that's one way it can get become a bigger problem down the road. Of course, if we do an audit and we see that you didn't enforce substantial damage rules and then they rebuilt either without a permit or incorrectly without coming into compliance, that can definitely cause an issue. And yeah, it could definitely cause an issue for you as an individual, as the floodplain administrator who didn't do the enforcement actions. And then, like I said, we've had communities having to pay to correct violations that they didn't enforce, and that was not good for them. The Kansas BFE portal, again, you might be able to, as part of your homework, looking into a potential violation, if you come in here, you can look at the approximate LiDAR, and that might tell you if they're potentially eligible for a LOMA, which I will stand by that. I don't know why people have an issue with that. I've had people say, like, you can't resolve a violation that way, and I say, why not? Because getting a LOMA, again, it means they should have never been mapped into the floodplain in the first place. So I'd say that is a valid way of resolving a violation. You get a LOMA, the floodplain regulations no longer require, or no longer apply, and then you've resolved the violation. And yeah, so that's just one tool you have if they qualify for it. I mean, sometimes you can fix violations without having to do a major retrofit, just depending. We can try and help you find solutions. I've been through a lot of really wacky and weird floodplain situations, so there's a little bit of nuance, a little bit of gray area, a little bit of judgment call and stuff. So there can be creative solutions that can help people save time and money if you find the right solution. So definitely let us help you with that. We've seen a lot of strange things happen. Just a reminder that utilities have to be at or above the base flood elevation, so they're not required to be elevated as high as the lowest floor, but they are required to be at least that high. And if not, it's considered a violation. So that is also part of it. And then FEMA is doing, I guess, yeah, machinery and equipment discounts, which is like 5%. Like I said, insurance has changed quite a bit since the implementation of risk rating 2.0. So this might be a bit of a selling point. You can get a 5% discount if you elevate your utilities according to the type of foundation that you have. So if it's a slab on grade, it has to be the next floor or higher. So that would be like the attic level on a single story slab on grade. For the basement, it's just the floor above the basement or higher. So that could just be the living floor. Um, uh, Elevated without an enclosure, just on that elevated floor. With an enclosure, it has to be on the floor above the enclosure, or if it's a crawl space, just the floor above the crawl space. So it's kind of a black and white type of discount based on your foundation types. And it used to be where insurance was a compliance tool because they would seriously penalize people by making their insurance really expensive if they didn't have it elevated properly. That's not the case anymore. It's either you get a discount or you don't. So we don't have that tool, and we've kind of had a dissolution between regulations and insurance, and it's kind of, I think, probably impacting compliance. But I mean, I don't know. There's a lot going on with risk rating 2.0, so yeah, it's just a lot different from the legacy system, and there's a lot of litigation going on regarding that. So again, that's a 5% discount. There is some kind of proper flood venting discount as well, so that can help potentially if you have a venting violation. You can get a mitigation credit based on what your lowest adjacent grade is, your first floor height and foundation type. There's also one for construction materials, like if it's stick built housing or if you have like the CMU, like cement type building. So yeah, FEMA's changed the way that they rate it, but if you look into some of those that might be applicable to your particular violation that you're trying to resolve, that might help a little bit if they have insurance, if they're interested in getting insurance. Just looking at some of the other factors that now go into what the premium is, nobody really knows how they're coming up with premiums. It's been referred to as the black box. So they say they're taking all of this data and then we don't know how it's weighted. We don't know how they're coming up with the numbers, but apparently this is some of the stuff. So they have the mapping data, of course, but they're not really using the flood zones anymore. There's catastrophe modeling, data from other federal resources like the Army Corps and USGS, the replacement cost data for their structure, their past claims history, the cost to rebuild, elevation, those types of building characteristics that might help. So it's very confusing. It's not very open at all as to how this is being done. So we don't have this as much as a compliance tool, but it can potentially help if you explain some of the discounts that they supposedly get based on those things. I know it's not very clear, but that might be something to look into if you're having a hard time. Structures that were substantially improved without being brought to code. Of course, I mentioned this substantial improvement in damage. There are two sides of the same coin, so this is kind of the same problem. Where either the cost to repair to the pre-damaged condition or the cost of an improvement is equal to or greater than 50% of the market value for the structure minus the property, then it's considered either substantially improved or damaged from any cause. So when that happens, they have to be brought into compliance with the current base flood elevation in their lowest floor. So that could mean filling in a basement. So that's an issue, like I said, I've been dealing with since yesterday. It was brought to my attention, and that person is very upset that they have to fill in their basement. but they're not getting a permit until that is done. So that's the thing. We withhold permits, we withhold approval from other departments until that's done. So in this case, this is a very strange addition. I'm not sure if it's still under construction here, but basically this is some kind of an addition built onto a manufactured home. And so when we're dealing with manufactured home, they're less in value, and so it's a lot easier to hit that threshold. So again, something to watch out for, and it looks like this might have other violations as well from other departments. It doesn't look like it's very like professionally done, so that's something to watch out for. If you have cumulative improvement in your regulations, then you have to track the permits over the last 5 years. So that's also part of doing the homework. Um, First floor height, this is one of the rating variables. It's whatever the first floor is that's above the grade. We insurance stuff. So yeah, just on insurance, it's not as much of a tool. It could be, but it's very convoluted at this point as to how that works. So moving on a little bit, the statute of limitations for a floodplain management misdemeanor crime is 5 years. So that's kind of the threshold where you're able to do enforcement actions per the Kansas statutes. I mean, it's written in there that every day is a new violation. So you can use that to your advantage if you end up having to do fining, or if you end up having to abate something in the Kansas statutes. It must be commenced within 5 years after it's been committed. So if you find something that's older than that, you may not have the authority to do all the enforcement actions that you would on something that hasn't been 5 years. Again, you might be able to get voluntary compliance. Um, and FEMA does not care about that. If they find out about it, they still want you to fix it. We had some accessory buildings that were built in like 1998, and then someone just recently tried to get a LOMA on that, and then they were trying to get them to bring it into compliance. So you can see the issue there. We want to avoid that happening. Variances. So again, this is the due process. You have a right to appeal. People will want you to award them a variance to resolve the violation they created. Variances are not a way to resolve violations, not in any way. So definitely don't try to take that route unless it actually qualifies for a variance. Like sometimes they just say you're going to have to give me a variance. You definitely don't have to give anybody a variance for any reason. The appeals board would be reviewing that, and they should be well educated on what qualifies for a floodplain management variance based on the FEMA guidance. So a variance is not going to relieve them of floodplain insurance requirements either. So make sure that that's clear. There's no opting out or waiving of compliance requirements. Sorry, again, regulations and insurance, they're on different streets now. So this is just an overview of conditions for variances. Has to pertain to the property, not the person. It's not personal in nature. It doesn't have anything to do with their finances or their disabilities or anything like that. It can't be issued in the floodway if it's going to increase the base flood elevations, no increase in flood heights, no threat to public safety or nuisance, no extraordinary public expense, victimization of the public, or fraud on the public, not conflict with existing local laws or ordinances, and the minimum necessary to afford relief. Insufficient reasons. It's depreciation of the property, inconvenience to the property owner, their circumstances. It's not about them, it's about the land. Variances are for the property, not the person. No financial reasons, no aesthetic concerns, no hardships created by their own actions of violating the ordinance. You have to notify them in writing that it could increase their premium, risk to life and property, and then definitely maintain that if you do issue a variance that qualifies. And again, they are at more risk, and it could be a life-threatening risk, not only for them, but for first responders. We have to keep that in mind. Yeah, they gave him a floaty with his approved variance. Again, disclaimer, variances are issued administratively for low damage potential agricultural buildings. They can be built at grade and be wet flood proofed. The same thing with functionally dependent uses like a boathouse or a marina or something that qualifies that has to be near water. And the example they give is like a loading dock. It's not like a place of entertainment or employment or something like that. It's like work that has to be done near water is the example that they give. Again, keep full documentation. Here's the guidance on this, and make sure that your appeals board has this bulletin and that they've read through it thoroughly so that they know what's appropriate for a floodplain management variance. And they should not just be granting, whatever request comes across their desk. And FEMA might notice this if you're granting variances, especially a lot of them that's really bad. You want to avoid this as much as possible. And they may, look into it and investigate your pattern of variance granting and take appropriate action. So again, try not to issue a variance and don't get into a slippery slope of issuing them. Again, we have ways of finding out about that. So if they get denied, the applicant can take you to court. If they get denied their appeal, you may win or lose. Sometimes people think that you'll just go away, but we don't do that. We continue until this is to the maximum extent possible. If they're not willing to correct problems or work with you, you could end up in court. Make sure you're working with your legal staff. Make sure you've kept good records. Like I said, treat everything like you're going to court. If you do, be prepared, have a pre-trial conference with the attorney, refresh your memory, review your notes, dress appropriately, turn off your phone. If you have to testify and speak to the judge or, the attorneys, speak clearly. Don't use acronyms, spell everything out. Think before you speak, be honest, just stick to the facts. Don't get emotional, be polite. Ask for a repeated question if you don't understand or if you need to think about it. And if there's a jury, speak to them as much as you do the attorney. Handwritten records may be challenged, so make sure that they are legible. After you've done everything else, notice on the deed, if you've lost at court, you have these two final options after that, just to, tie everything up. Like you could not get this resolved. You have the notice on the deed and the 1316 denial flood insurance list. So we encourage the notice on deed. Sorry, we're going a little bit late, but this can work a little bit better than the 1316 list. It's common. You can't get compliance. So you put this notice on the deed. So any future property buyer, prospective buyers are going to see this. It's going to come up when they look at it so that they know that there's a violation here. There's a violation issue. And that can create incentive for the seller to fix the problem because, people may not be interested. And that's what happened with that house that was built too low that I mentioned, where they couldn't get the certificate of occupancy. They ended up with a notice on the deed. And that way any future buyer is notified, because if you use the 1316 list, they might not be notified, and that can punish the new buyer instead of the violator. So that's why we suggest this. And it's tied to the deed permanently. So it's also called a non-conforming zoning affidavit. So if anyone has done this or has experience, I'd like to hear about it. Basically, you're allowed to put documentation with the deed that this house is, out of compliance, and insurance is probably going to be very expensive. Make sure that the legal description matches what regulation has been violated, the map panel and the flood map, and then post a new notice on top of that when the violation has been corrected, because it never goes away. The notice on deed stays there. Then you just put a new one that says this has been corrected. And again, 1316, this is the FEMA process. It's a list that will deny them NFIP flood insurance. It doesn't really work for violations that don't involve insurable buildings, and people can also get private flood insurance now and meet requirements, so that may not have as much pull as it used to. And like I said, new buyers may not know about this until they try to get flood insurance because we don't have disclosure laws in Kansas. So yeah, it's not perfect. That's why we do the notice on deed over this. And of course, always encourage flood insurance when you can. It's the best way for them to be able to recover if something happens. And I'm sorry we've got over late. We do have a new website, so be sure to look at that. Let me know of any resources that you want. The technical bulletins are all online. I'm happy to follow up. I'm happy to talk about violations with any of you. You could potentially be held accountable for not doing enforcement. So that's just something to mention and be aware of. And then this is kind of about employee, accountability for self liability. Anyways, okay, sorry, we went over. I apologize. Last two poll questions. So there's one more question, and then if you want a certificate. So, which activities constitute development in the floodplain? Filling and grading storage of materials, repair to damaged buildings, roof maintenance, or all of the above. So if you have answered both poll questions and you've been here for at least an hour and a half, then I can submit to or give you a certificate. Um, Otherwise, I can't. Um, Maybe if you're not a CFM, but um, definitely ASFPM holds us accountable for making sure that we are appropriately issuing those credits. So it looks like almost everyone. Am I the 13th person that doesn't participate? Is that me? I don't know. Um,
I don't think so. It looks like you and I are not included in the
okay,
participant list.
cool. Okay, well, this is your last chance to answer the last poll question, and then we'll share the results.
All right, I'm going to close it now.
Yeah, so it's all of the above. Any man-made change is considered development. Okay. Um, so all activities unless explicitly exempt. So then we can launch the last question. Are you a CFM? Would you like credits for this? And then we can go into questions. Again, I'm sorry we went over a little bit. I thought I might go under and then I went way over. Okay. So yeah, we should have the certificates out here soon, like in the next couple of days or so. For the 2 credit hours, if you answered both poll questions and were here for at least 75% of the time. And then, of course, this is our contact information. Caitlin is new to floodplain stuff, so she's been, training on it, and I've been including her on, various emails on floodplain stuff. So, okay, so it looks like the 12 people that have been participating have answered. So we have that. And then I think I'll stop sharing my screen. And what do we have in the chat? I can send this out. Just let me know if you want the slides, and I'm happy to send them out. Okay, so someone does have insurance proceeds. That's cool, but they use them for house fires and have not thought about flood damage property. So that, yeah, I'm not sure what that process looks like because again, I haven't seen that. Oh yeah, if you guys want to come off mute and say anything, that's cool too. Um, yeah, I can send out the slides. Okay, I'll send out the slides when I send out my follow-up survey, and I'll just have them in there so you guys will have these. And then of course you can reach out by email with any questions that you have. Again, I'm really sorry that we went over time. What was the website that we shared in a previous class that showed all the waterways? Is that maybe our effective floodplain viewer? I can send that. Okay, it's not on our website. I'm not sure what that would be referring to. Um, yeah, I'm not sure, but you can always catch our web resources class on the 19th. I'm sure if it's there that, oh, the way back. So how can you find a map of the community that shows what areas are in the floodplain? Definitely, our effective floodplain viewer. If you have digital maps, I'm not sure what community you're representing, but we can see where your maps are. If they've been updated, then they'll be on there. If you're part of a mapping project, or there are some areas in Kansas that don't have regulatory maps yet. Ah, so Oldsburg, I think, has the new map. Like, I can't remember what county that is right offhand, but yeah, I can definitely get in touch with you and we can look at that, and I can show you if you have maps, Potawatomi. Yeah, so definitely if it's in Potawatomi County, they have very recent maps. I remember helping the city join a few years ago, so I can definitely show you the effective floodplain viewer. I'm not sure if Allsburg has floodplains. I'm kind of thinking it might be a no special flood hazard area. And if you don't have special flood hazard areas, then you can participate without passing an ordinance. But I'll take a look at that for you and get back in touch with you. Again, if you could please participate in our post-training survey, I'll send out the slides with that and then just give us some feedback so we can help improve this. But if nobody has any other questions, I can let you go. 10 minutes late, I'm sorry. Um, but we appreciate you being here. Hope you have a great rest of your day.